When I woke up yesterday morning, federal law allowed an employer to terminate my employment simply because I'm gay, or to fire many of my patients because of their gender identity. But in a monumental moment for the LGBTQ community, the Supreme Court announced their decision yesterday morning, acknowledging and ruling that, as a matter of law, Title VII of the Civil Rights Act of 1964 protects all of us from discrimination, no matter who we are, how we identify, or who we love. In Bostock v. Clayton County, the court held that the Civil Rights Act requires a conclusion that is, quote, equally simple and momentous. An individual's sexuality or transgender status is not relevant to employment decisions. That's because it is impossible to discriminate against a person for being gay or transgender without discriminating against that individual based on sex. We learned this news while still digesting what happened last Friday evening when the Department of Health and Human Services announced an outrageous and discriminatory rule that opened the door for any healthcare provider, anywhere, to deny treatment to a transgender or non-binary person simply for being who they are. To finalize a policy like this is wrong at any point. To do it during Pride Month and on the anniversary of the Pulse nightclub shooting in Orlando is an affront to the entire LGBTQ community. And to do it in the midst of the worst public health crisis our country has ever faced is immoral and unethical. As the number of new COVID cases increases, and as we learn about more names of transgender people of color who are the victims of violence, we should be expanding access to care, bringing in more people to our healthcare system, and making sure that everyone can receive the care and the compassion they deserve. As the medical director of the MGH Transgender Health Program, I know that many of my patients may be excited about yesterday's news, and also deeply concerned about whether and how the court's decision will affect the hateful, newly announced rule from the Trump administration and the Department of Health and Human Services. I am not a lawyer, I'm a physician, but here's what I understand to be going on. First, as of now, the Trump administration rule states it will not take effect until 60 days after it is formally published by the federal government, which won't be until Friday, June 19th, 2020. That means that nothing will change for you under the Affordable Care Act until at least the middle of August. Even before the court's decision this morning in Bostock, advocacy groups like GLAAD, Lambda Legal, and the Human Rights Campaign announced their plans to file lawsuits to prevent the new rule from taking effect. The Bostock decision provides new and incredibly powerful ammunition to these and other organizations who plan to fight in court to protect your rights under the ACA, especially recognizing that the language in the Affordable Care Act mirrors the language in the Civil Rights Act. To justify its rule change, the Trump administration relied upon a federal case from the Northern District of Texas, which has been appealed to the Fifth Circuit Court of Appeals. And on June 2nd, that case was put on hold, pending the Bostock decision. Now, does all of this mean that our allies will win their lawsuits and prevent the rule from going into effect? Unfortunately, there's really no way to tell for sure. These lawsuits could delay implementation of the rule, they could prevent it entirely, or in the worst case, they could lose. They could also take years to resolve. The cases that led to the Bostock decision were filed in 2017 and 2018. And since it's an election year, it's fair to anticipate that the Trump administration will fight in the courts to energize its base. What we do know is that our allies now have an even stronger case in defense of your rights, and they have my full support, both as a physician and an American. You have my full support too. Please continue to get in touch and continue to make an appointment if you're feeling sick. Don't let this controversy compromise your health or your dignity in any way. I'm running for Congress against an entrenched incumbent to bring science, evidence, and facts back to Washington, and to guarantee that every person in our communities gets the care and compassion they deserve. My opponent, who opposed the Affordable Care Act in 2010 and has failed to support the LGBTQ community at virtually every turn since before he even took office, does not agree. In Massachusetts, the first state to declare that all members of the LGBTQ community have the fundamental right to marry who they love, It's time that our representatives share the values of our communities and lead with those values every single day. I will be that representative, and I will never give up this fight. If the courts have not resolved the impact of the Bostock case on the new rule by the time I take office, I will work tirelessly to enact a legislative solution that protects the dignity and health of all Americans from this type of discrimination. This is my promise. This is our fight.